Okay, me nyame da ase. The edikan ma memma enyina yenti ase se contrary to say the siwa bonten say Mr. Nas echo Ghana court ma Ghana court to na asem guye no they call US court the US court ajatum make judgment amano no enya sa na tie
mo
asem no ya asem a different asem enya asem ba akopena. Indeed there also tie ase say case laws are territorially bound. Titu your criminal law, for instance, and even other laws. And to be to my young phone or Ghana or America, Southern and young phone so. Or we should be my young phone so America, or come Mexico and young phone so. So the laws are confined within the territories of the country.
And even within America, no crown state to be. Across the state to be crumpa.
Yes. And until LGBTQ, no America, some states G2, but some states soon the and any possible say, as embassy or Ghana near the America could be. Sasana tell dia, any America so same shake, waiting media baha. Then so, Muku be crucial, na be kusia. And answer the act or the offense occurred in the territory or the jurisdiction of that particular country there. And your home run near the Bay Juma. Said you America for me, do Ghana. No one mobile corner back second or back or so. Yeah, for America say good you must say Ghana run of my day, a buso. America need namha, and UK need namha. No the carbon power Ghana ha. Ghana run my day, Wabusu, into Ghana need be dinasem. And to hear as some I came or rack in upon any. Penny Anas and Semia. The offense Nankasa was committed on the soils and within the jurisdiction of America, the United States of America. And on that basis, and need in Ghana ha any when they compare to the AC Wahana, the AC Wahana there, Honorable Kennedy Japan made those comments in Ghana here. And in Ghana court was in a bit my idea. And this will be cast a sebu. Asem no de baha and a year in the year near the America yakudia. It is never the case. The facts were entirely different. Now, quite say, asem no, sometimes we can spin it within social media, within the media space. Now, by say, even though there is an element of truth, you know, ne we yere ne adane no. I say be obi o shetuntum, no who so front to matuntum. O front to matuntum am pay nyine so front to matuntum. And so o front to chetimika say, oh, any be a year sinifi. Bi so na ye na sinifi. Ebi ani yesi wo hene. Saka mamusu yesi wo hene na yesi tuntum. Enti the first social tuntum no nche say eyi na ye dey esi ofi. Bi kura na wo hene na ye dey yesi. So there has been systemic misinformation that's spinning certain aspects of what is going on. It is never the case to say the matter was here and the court did not treat it well and the court abuche. There were two different issues, two different set of facts. Say the same set of facts again to me new abuche. And unti we ya Honorable Kennedy Japan ne papa bi friend that the Fred. One more koye interview in America. Interestingly, even Kennedy Japan was in his residence in America and now make his interview on Zoom. And the gentleman also interview was also in the jurisdiction of America and also interview. And the act which constituted the offense of defamation was also done on the soils of America. Didn't now be dino. And even though Ghana for you know kunya asem no, na ye dey America na obey dey ebedi no. Enti enchemu kakra so a dey ewo ho no. Again, ade ba ko say ma chonte menka dey.
Enti on kapa.
Ade ba ko so e wo say adwen ba so na
say. Ana ya menyeje ho ma o.
Oh, there be say me dey. Me need say one thing to what ya ko. Ade ba ko say me hu ya adwen ba so na say country bia wo kwan ofa so edi na asem. Yeah, quite fast so your law no see working no. We take a cue from the common law. Common law no US for. Into your system no a bit different from UK for. Your system no a bit different from US for no. Yeah, over Ghana ha. There were two types of trial. If it be summary trial and other ones no so no. You find a trial by indictment. Summary trial na there asem no a straightforward. Offense na answer crime na ya commit no. Enya dia e hu anase e was rubia. In prepu, the judge back up bit so, and the judge will apply both the facts of the case and the law of the case. Not the law, nor they are coming to the determination of the case. But don't hear trial by indictment, there, it had no offense in this one. I also be the second who will be no. In the case of murder, no, and Marines to say, ebi a judge baako for nko transfer ontimi mu atenten ye ma ne nyi enti yen frame kofo bi efe mu jury na omomo ano ema ye ni asem no the jury will come out only looking at the facts not the law no omo de omo verdict aye de aba ade baako we see and said the verdict of the jury is not necessarily the judgment of the court and the jury do omo verdict be we are ansa na court na ye de adopt over instant case here they compare to in America no in civil matter no even though offense no be a Ghana ha defamation may not be seen as an indictable offense no or no defamation indictable offense into a sopa into a one of the omu jury trial into jury no ankwa one more lawyers ni law hunim they are only privy to the facts now Ghana ha usually we take a nipa 7 America so more nipa 8 no more better so they are only looking at the facts into say jury transem so now one will look at the facts and they come out with a certain decision and a certain pronouncement that you cannot compare to or be a judge in the TNASO because juries don't know the law. They are not lawyers. They don't have any legal training. They only come and look at the facts and they may miss a point of law. And again, that comparison, I don't really get it. Why you compare a jury trial to a trial of summary conviction where a judge says on it? Because, hey, America could a jury 8 quarters now so and a Ghana judge it's not no basa. You can only compare a jury trial to a jury trial and a summary trial to a summary trial because jury in one more law. Now we have same way Canada Japan the jury had come out with their verdict. No more verdict no almost honorable Canada Japan found on a culpable or guilty say ampa wa defame anas. No more the taboo anas be a friend damages of an amount of $18 million to Papa Canada Japan so. Oshe sport records in the money idea. Initially, no Canada Japan lawyers FRL said the amount is so outrageous. It cannot sort of interior day on teso. Court no shena jury no and a court no enter and sana court na adopted. Now a move on court no case okay one more ever but before that they will look at that application. But before that no court no say one more examine another aspects of proceedings na and no your friend punitive damages. Unum so court damages you say you obi aya on so na okobọ neka ye wo two say a obi aso court no ye either in the form of a sentence and in the form of conviction and damages conviction there na in criminal trials and no nipa na betumo ya bo obi tu ya ku obi ya rape obi and no criminal trial and no nipa na betum but when it comes to civil trial ye mfo obi antum obi de oka ye mfanentum obi de femu ye mfanentum and no ye friend of damages ni esika ye hwehwe ka ye de ebebo na damages no ye wo mo hodo bebre ye wo actual damages ye compensatory damages and ye wo damages so and say punitive damages na briefly no mamema o scenario we ni nyina na etifo ni ahwefo nyina ntiase fa ne say obi kura car and wo de car ni dream car pa na wo de akobot taxi driver car kese akobot taxi driver and taxi na say he has caused actual cost to the car na taxi driver ni use the be charge no for actual damages. Again, taxi na nkwadwuma bosome mienu bra ye repair taxi no. Nti so compensate driver no car wire de wabo and for his economic loss. Obetwa compensatory damages. Na court no say timika cho say okra na ye hwe wo car twi a enye fe. De be twa so ma ni panyina hu so ba court ya twa so. That is the punitive damages. Na American say ye mu no. The punitive damages is also determined differently from the other damages. And the court not tell us a court no busa some be punitive damages no. And a jury ni say oh one more can punitive damages no any actual and special and compensatory damages ni na able. And a court no tell my say no that is not the instructions that was given to the jury. Now there ba kwa say in jury trial it is the judge that directs the jury on what to do and he gives specific instructions. It is a jury obey the instructions of the court. It can constitute a ground for what you call mistrial. Mistrial, they say there has been an error within the trial proceedings and also processes. And the one that Canada Japan almost sorry no say now judge, are there say a treating is separately from the other form of damages and then no money and on that basis no sorry raise a motion for mistrial. Say any adwumadi omudi nyina no na jury no and your moon so I don't have for money so money lawyer for budim the encoso. On that basis and court no encha trial proceedings no my nyina because almost to say So my mistake was had here, and no my mistake so in the whole trial. And the court said, well, this is what the jury have said. But if this is the objection that you are raising to what the jury have said, based on mistake or Maya, which is patent on the face of the record there, on that basis, you have to submit a written application. So we are at a stage that the jury has brought their verdict. Mind you, verdict is not the same as judgment. It is only when a verdict is adopted by the court that is where it becomes a judgment of the court. And even at this stage, now there has been maybe a pseudo injunction on even the verdict of the jury. Why? Because now there has been an objection that has been raised even against the verdict of the jury because of some mistrial. So the judge says that he wants to give them 30 days for him to hear the mistrial application to determine, say, AMPA is a grounds for mistrial or not. Indeed, there are two options.
But just there be a one fan count, so one fan shim, say, hono there. Also, to me, a raise bond be a raise sikano 18 million. And they say, be a hold on until say, you be the assembly and sana damages no be to an answer to honor sikano say, or raise sikano at the Tonya.
And this actually say we don't have a judgment as of now.
But according to one of the lawyers now or more announced lawyers now, what you do over there in America is that also raise bond, who raises cano in bond. It says cano any ansana twaso or matwaso.
No, but you see, that can only come after a judgment you have obtained a judgment.
No, even as the Interca says, there is a pseudo injunction now. The verdict, there's a judge, any verdict, and tuma. Say, opa kotrobra. If you doesn't want to use the verdict for anything, opa kotrobra. Yes, I know.
No. So let's understand that part carefully.
Okay.
So the verdict has come. It is now left to the court to say about adopted verdict. Mind you, class verdict in the Ken's lawyers had earlier on even raised an application saying take Sikana because it was so outrageous. In the answer now, assuming said judge no his application or test what, and also would we be going about to say
okay? So in the same way now, beside the same people now, the same issue now, say. Japan lawyers non tiasia and to marriage your friend say person family in writing no more sadia na more contest no more contest verdict no you have even sika also tuano more share can sika no asem if the system doesn't accept it then I would disankom no because
yes so you must understand say the verdict in many jurisdictions, particularly in Ghana, the judge is bound mostly by, or usually the judge is bound by the verdict of the jury. So you can predict that the judge is going to adopt the verdict of the jury. But in most cases, you may put in what you call mitigation measures. Mitigation measures are going to be now you're doing 25 years. Now you catch a judge and say, oh, or your first time offender, or you say you can see that provocation assembly trained in judge and so. Even though say there has been conviction, in terms of the sentencing, the judge can take your plea of the mitigation and even reduce the sentencing. So within this context, the verdict of the jury was not in dispute, and you have the right to even mitigate the verdict of the jury. But outside even mitigation measures, mind you, the verdict had not yet even been admitted by the court.
What were they contesting? Because if the thing has not been admitted, because I am a lawyer, are they admitting and everything? Waiting concern you, concern me.
Okay, so the say what is now being contested is not even the decision of the jury. The jury erred in the processes in arriving at their decision. Na kwa ba so no mo fa so yes am for so no enu nti Canada Japan mo lawyer so mo file for mistrial de ko ba ene say wono mo damages na ana say fines ana say kai bo Canada Japan no you determine in two phases based on the instructions of the court. No, court no my jury net assess the decay no, you be determine the actual and specific damages. No, at the chena ye ba, ya sa betena se the punitive damages. No,
but kwesi.
If I land that, I'm sure
okay,
if
all right.
I was allowed to land that. But what the jury did was that one more judge in the can say, okay, and they are sabbath and I say, you have punitive damage. The jury in this catcher will say, oh, you cry other damage $18 million near they buy, and they can no judge and they said, no, that was not the instructions of the court. Until you didn't obey the instructions of the court. But mind you, one grounds for the application, or that can be a basis for mistrial, is when the jury does not go by the instructions of the court. And in the market in the Japan, lawyer sorry fast who said there is a loophole. Before now go by the instructions of the court. I did some munchiche me na mukaka boom.
But judge no say for that reason may accept a verdict nana.
So the judge because of sa mistrial application no mo emeki no. Remember so no make sa application orally. And a judge no,
but what happened was that judge the loophole no mu you know. Judge no ankasa so ehun no say friend saying go and correct this and okaso mo correct no famra na.
No, so I'm making oral application for mistrial.
So in principle can't it be seen that taking said judge accepted or admitted verdict.
So now or more judgment or more family in there's no judgment. There's no judgment within the matter.
But then in our jurisdictions, you know, and Kabi and Kawe no we said okay say Hassan and jury no the verdict near binding on and as a judge you know also a jitum no nka ya ha no ye beka say nka ba apply say omu stay your friend is saying execution of the judgment and
that is if there is judgment.
No,
see, the jury in the Wakoya Jumong, at the end of the day, you call something summing up. The judge will now sum up every matter. No, I heard so jury in say Bibia or Moka or Moya. Aha, you really who say jury in and son a judge and Bedia de Atum. Now, when I no more yes, I than a judge who say jury in say instructions need home money so. And the other who's a law and strategy in a tatiso. And the other camp on came camp.
About okay, no, did that stop among proceedings?
Yes, so now the level of case in the 1 year is for the determination of the application of for mistrial. If that is to be determined, that then practically it places an indirect injunction on even the verdict, because now the verdict is hanging. As of now, we can't even proceed with the verdict for even the adoption of the court, because now
at what point in time and omo try say omo can 18 million no say at what point in time?
Okay, so when the jury had earlier presented one more verdict, that is where Kennedy Japan lawyers also came in to say
before the supposed your friend is saying loophole
damages were determined. Yes.
Before muhu loophole.
Yes, before muhu loophole. Yes.
But doesn't that?
Someone say they know say case in baby edu no omo lose. Practically, my main fanasa. I mean within the simple language, omo say baby edu omo lose. Omo come am so. Then at that time you know more be fined for punitive damages, which is also will be determined on its own. No more say some for a mistake. Now, they were going to say, in jury trial, we mistake about the assumption is that, you could have as well made a mistake in the whole trial. And there are a lot of legal precedents. People would then, based on that precedent, and set aside the whole trial by calling or filing application for mistrial. Until a loophole no be able and will take advantage of it.
And the young come social media and the attitude in are you creating the impression, sir? As a new year, and some common aid in the Taswana.
One, I did back say somebody like Anas beyond the maybe monetary interest a woman, he wants to clear his name. because he is a lawyer and he's a senior lawyer and a seasoned lawyer even more than me. I don't see the reason why there is no judgment in the matter. Yes, you bring it out as you've won. I mean, and you see the word they use is that they've won an award. They never said there's a judgment too. They said a jury award. The Ben we are still called to be a jury name award. It is the court that makes a final judgment.
Even in that jurisdiction.
Yes, but you see, at the end of the day, the judgment of the court will have to be grounded and based in law. The jury doesn't deal with law. The jury only deals with the facts of the matter. And the facts of the matter, no, based on the facts of the matter, we see that you are guilty. And then it is then left for the judge who is sitting as the bench, to then justify that within the context and with legal backing before that becomes a judgment. Oh, into what has happened, the jury awarded him all right, which is in no dispute. But that has also been challenged because it has come to the realization it's a jury need a mistake.
On my date, yeah, on writing. No.
I spoke to Kennedy's lawyers almost by hopefully they were supposed to send by Ochana, but almost latest by Friday they normally call. But the judge says within 30 days will be ruling on the mistrial application.
Whilst at it, then also 80 million. What happens?
As of now, there is no judgment, so there's nothing bounding them to do anything until the mistrial has been determined and the judge proceeds to make a judgment. Nothing. There is nothing to work with.
All right.
There is no order. Let me put it that way. There is no order against anyone.
Okay. So now let's go back to issue now. All can say, say Omo. And time is not on our side, but let's try to see if we can do something.
But
let's see if we can do something in 2 minutes. Sir, I had the no announce Kosu Canada Japan. I judge for net now, so dear Sam. But America, the end there, you're selecting Crofobinoma, Womunya judge for Juros, and almost selecting more Motana, Assem no so. Into we are normally a bread judge and a judge and so. Adia famra tukum namra asili ansana ya jatum. Is that what you're saying? That's the difference.
Yes, sir. You use common law. America use common law. We use sometimes even hybrid system. We don't use our law. The procedure.
You are saying that it is misplaced for somebody to say America for no ehunu Ghana for ehunu di.
Asem no kwa nyape asem no say asem ba ko na ye de kwa Ghana na say de kwa America na.
Ni defamation kura but be a fact.
So but the facts are different. But the facts are different. When you see in criminal, for instance, in I'll send you the one more rate and as a rate no. Always state defamation, but they will take the count of the offense and count no. But always state the particulars of the offense. The particulars of the offense no, and they bet share the facts and the details of the offense. The facts of the say Nina Yapa and Kayentimi ni Ghana Semo America. Because I told you that laws are territorially bound. In the same way, Ghana Intimin, they are entirely different things, even though the offenses are the same. No? The particulars of the offenses are different. And again, if you go to America, the burden of proof will be different from the burden of proof in Ghana. Well, if you are proving the burden of proofs are not the same because we use different jurisdictions. Yeah, the proof in criminal law may be beyond reasonable doubt. Civil is usually on balance of scale, preponderance of probability. In America, they may have their new offense be at their old thing. Even if it is the same, the weight of evidence that you need may not be the same. What I say, it will be very simplistic for anybody to say, hey, Ghana, they assemble, no. Indeed, if that is the logical, and then you only collect soon a call, and now as a call Supreme Court or car say, the decision of the High Court to say his description of Anasa was unjudicial. I don't know the say also took Ghanaian court to correct it. And again, mind you, even in America, granted without even admitting, Kennedy loses the mistrial application, and even the court adopts him as a judgment. The verdict has a judgment to Ghana. Kennedy Japan still has recourse in law. He can go to, let's say, if the case was held in a circuit court, or which mark a higher court to set the judgment aside through an appeal or any if so who's a procedure he can go for an order of certiorari right. Obeti misu we are court say high court any amount which mark a offender say Court of Appeal, and even to the Supreme Court. As same way, if you are rate now, I'll send you the rate. It was in 2022. It's 2025. Indeed, there is a mistrial. No more some combu. Now people are now ready to litigate. We have to earn 4 or 5 years.
So if anybody says, sir, Kennedy is supposed to cough up some 18 million USD. Yanka saying channel.
On judgment to run the money in read the entire say.
Because you have been commercial. I mean, try verdict, so except rate, no, try rate, no. Now, I
can forward to you right now.
All right, so now, be a young quite a fast, I better so I didn't come on going forward. Because me that's CP, and nombre. Lawyer, papa. All right, go.